And President Trump's legal advisor is reportedly getting ready to deliver a letter to Special Prosecutor Robert Mueller, outlining the president's reasons for being reluctant to talk with him. Legal advisor Rudy Giuliani has said the president may not balk at a talk with Mueller as long as the question of obstruction of justice is not on the table. Can he do that? Joining us now for a look at that and a preview of another day of testimony at the Paul Manafort trial, A. Scott Bolden, managing partner at Reed Smith's Washington office. Good to see you once again, Scott.
Good seeing you.
Let's start with that. How much can the president dictate what happens if there would be a sit-down?
He dictates nothing, actually. This is all about negotiation, back and forth. It's fundamental to when you have a white-collar criminal case where you represent the subject and the prosecutors are trying to talk. The prosecutors want to talk to Donald Trump because they need to explore his corruptible intent. He's a subject of the investigation. That means he may become a target or ultimately could be prosecuted, less even being the president, of course.
So they go back and forth now leading up to this. If it comes to the actual, we're going to sit down and talk, if they're negotiating, it's not a subpoena, if there's a negotiation right now, can they be held? If the prosecution says we're going to agree to talk about this topic, not this topic, can they be held to that decision when it comes to actually sitting down and talking?
Well, sure, that'll be in writing. And the danger for Donald Trump is he's got to tell the truth to the FBI and the prosecutors. Now, remember, it's a deal. And so if the deal, nobody's going to go against the deal itself. But what Donald Trump is really trying to do is he's trying to limit what he can talk about verbally, obviously, forgive the double term, verbally in connection to the investigation. He'd rather have written questions. Look for some written questions about obstruction of justice because his lawyers will respond to that.
On the converse, why would Mueller even accept that? Why would he say, look, it's all or nothing here. You come in, you talk. That's what we need to happen.
He could, but his report at the end is going to be much more powerful if he's talked to the president. The president needs to talk to him for political and legal purposes to show that he at least tried to cooperate. But the president has been so critical of this investigation that it's almost a moot point. It really doesn't matter at this point. But both sides need credibility, and that's what this fight is about.
Can Mueller just simply say, here's a subpoena, you come talk to us, and if you don't show up, what happens?
He could. Now, that being said, and normally you'd be held in contempt and you could be prosecuted for not showing up. Here, there's an open question as to whether the president can be subpoenaed or even prosecuted. We'd be on new legal ground. No court, no federal court or Article III court has ever determined that. Under Clinton, they did issue a subpoena to him, and there was a deal worked out where he appeared before the grand jury by video, and he lied before that grand jury. Donald Trump doesn't want that because if you listen to the Washington Post, he has no relationship with the truth.
All right, let's switch gears right now. Let's talk about the Paul Manafort trial right now. Yesterday, it got a little interesting. It got a lot personal when it came to some of the revelations that were there as the defense is now trying to paint this picture of Rick Gates as someone who cheated on his wife, someone who stole money from Paul Manafort, someone who cut a deal with the government and is trying to save his own skin. Effective or not?
It plays out in courts all around this country on a daily basis. The effectiveness part, the prosecution has told you already that Mr. Gates is a reprobate. He's lied and stolen his whole life, and now it's all on display. That takes a lot. It takes a lot to take that, and he's taking hits from all sides. Of course, the prosecution has gotten it out. The defense is going to try to cut him up that way. Is it effective? It may be effective. It'll be up to the jury. But what's more effective is if they cancel out Gates, if they say he's not believable, even though he hasn't been sentenced yet, and he has every incentive to tell the truth, defense would argue against that. It'll be up to the jury. But corroboration, if you take Gates out completely because you just think he's a bald-faced liar trying to get a better deal, that would be effective. But if they do that, then what's left? The accountants are left. The documents are left. And on bank and tax fraud cases, I've been on both sides of the aisle. Those are tough cases to beat on the defense side.
So if you're prosecuting this case, and obviously, Scott, you are an attorney, you're thinking like an attorney, you're explaining this as an attorney. But for the members of the jury, what's going to stick with them the most based on everything that you've said? Are they going to focus more, have a bigger impact on the documents, or are they going to have a bigger impact on just simply, this guy doesn't seem like a credible witness, why should I believe him? We're going to say Manafort didn't do it.
Well, the closing argument, the prosecution is going to tie it all up. the defense is going to try to untie it, if you will. So they've calculated, that being the prosecution, they've calculated that the jury will discount completely. Worst case scenario, Rick Gates, right? They calculated that into their case already. And so now what they're left with and what they're banking on is no matter what damage the defense does, you've got the accountants, you've got the document trail, and what they're going to argue is that the documents and the accountant match up squarely with Richard Gates' testimony. That's corroboration, and that also means credibility as far as they're going to be concerned. The jury has to make that choice, and we'll know what their choice was with the verdict.
All right. Still have a ways to go before we get to closing arguments, but we'll have more in court today. Scott Bolden, thanks for joining us this morning.
Thank you.
Tucker Barnes with Check.